Jeremy Rosenthal. He's a trial attorney and founding partner of Rosenthal, Calabas, and Theron. Jeremy, it's great to have you here with us. One of the key allegations in the original indictment was that there were allegedly advisors that told Trump to call off the people involved in the Capitol breach, and then Trump allegedly did not send that message. Why was that dropped in light of this immunity ruling?
So one of the big things that we see in this, now it's 36 pages instead of 45 pages, they've basically sort of cleaned it up pursuant to the Supreme Court's order. Instead of calling Donald Trump the president or the 45th president of the United States, they took that language out and they put in there that he is a candidate for presidency, because being a candidate for president does not give you the automatic immunity that being the president does. And so what they're trying to do is they're trying to make clear that all the actions in the indictment were that of a candidate who would not be immune from prosecution, whereas if he's acting as the president, he would be immune. A lot of language eliminated directives to the Justice Department, which the Supreme Court specifically said those are going to be immune. Whether we like what the president's doing with the Justice Department or not, we elected the president of the United States as the executive to direct the Justice Department. He can do that, so you can't prosecute him for that. A lot of that language was taken out. As far as all the language that talks about all the things that he told the January 6th rioters via tweet, via message, they made clear, look, this was candidate Trump. Now, ultimately, it's going to be the judge who decides whether or not that is immune or not immune. But that's kind of what the indictment was trying to clean up.
And it's not clear if Trump will have to appear, as the special counsel has waived his ability. He's allowing Trump to forego any arraignment with this new indictment here. But for example, why would the indictment need to be changed? I mean, all the Supreme Court did was say you can't prosecute Trump for doing his constitutionally described job.
What they're trying to do is they're trying to avoid losing this case on appeal. The Supreme Court did two things which I think are very important as far as this prosecution goes. First off, they made these categories of you are absolutely immune if you are acting within your office, or if it's not an official act, then you're not immune. They did that. Another thing that they did, which is really confusing but very, very important here, is they said that you cannot consider things that he did that were official. You can't even consider them. You can't even talk about them in front of the jury. So what they did was they took out a lot of the language where he is communicating with the Justice Department. That was originally a big part of the government's theory, was that Trump was taking election fraud claims and kind of forcing the Justice Department's hand and saying, look, Justice Department, we want you to go to the states and say that we found a lot of massive fraud across the board here, and you need to go and tell the states this. So that was originally part of the government's theory that Donald Trump was doing, but now that Trump is immune from anything he tells the Justice Department, regardless of what we may think of it, that's why they took that language out, because if it had made its way all the way to a trial, that case is going to get reversed. So they had to gut it, and they had to gut it now.
And we know that in legal process, if there is some legal defect or something, they have 6 months to revise their indictment and put forward a new one, just like this superseding indictment we're seeing here. There's another allegation that was taken out from the original indictment, and that was that Trump's lawyer, his White House lawyer, allegedly told him that, he should withdraw his objection to the certification, and that Trump allegedly never did that. So why is that withdrawn from this indictment?
Again, probably from jacksmith's point of view, out of an abundance of caution. They just don't want to allow the jury to hear something that the government is going to have, or Donald Trump rather, is going to have a good claim of, no, that was immune. And not only that, the jury can't consider anything that we did between us and our advisors. If it's going to be close to something that would have that immunity, then what you're looking at is that infecting the entire judgment. So if he gets convicted like that and makes its way in front of the jury, Donald Trump's got a really good appellate issue. So Jack Smith is trying to declaw that, as it were, beforehand, prophylactically.
Very interesting, Jeremy. So we just got a minute here. Can you walk us through the step-by-step process of what happens next?
What happens next is we have an election, because there's just no way that this is going to make its way to trial, to court before the election. There's a hearing coming up in a couple of weeks. The hearing was originally to see what are we going to do because of this new Supreme Court opinion. Jack Smith is doing his best to address that, so they still will talk about that here in a couple of weeks, I imagine. But this case is not going to get to trial before the election. Donald Trump wins this election. You can count on him doing everything he can do to pull the plug on this prosecution. If he loses the election, then he is looking down the barrel of this indictment, and there's not a lot to stop it. So the election is what's next.
Trial attorney Jeremy Rosenthal, thanks for contributing to our program.
You got it, guys. Have a good morning.